Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, probably my least favorite topic of discussion here is anything involving those goddamn forced reset triggers, wide open triggers, or anything related to Operation Reticent Recall. However, there have been not one, but two huge developments, and you all need to be aware of it. So today, let's get you educated and let's talk about major developments in the trigger turmoil. Okay, before we get going too far down the road we're going down, proud to announce that this video is being brought to you by Full Send Precision Rifles. That's right. Their mission is to provide superior customer service to all, where their knowledge is always free. They treat their customers like family, striving to deliver the finest precision machine work in their role as your firearms manufacturer. Now listen, you got to check out some of the stuff they're doing here, because Full Send has their own line of precision rifles. They also have their own line of suppressors known as Silent Night suppressors. They do specialize in left-handed firearms. They do custom build and repairs, laser engraving, welding and repairs, NFA builds and repairs, antique preservations and repairs. If you're looking for a long-range precision barrel in just about any caliber, hey, contact them. I'm sure they can get you set up. Listen, if you're really ready to make an investment in a high-end precision rifle, visit Liam and all my good friends down at Full Send Precision Rifles. For more information, visit them at fullsendfirearmsandammo.com. I get it, it's a mouthload, but fullsendfirearmsandammo.com. We'll also link all their description information in the box below. Okay, here we go again, down the road of wide open triggers and forced reset triggers. Two important issues to be aware of. The first is Operation Reticent Recall version 3.0 is now underway. There is a whole new slew of nasty little letters going out to individuals who purchased rather lawfully these triggers a couple of years ago, and now the ATF is of the opinion that you are possessing an unlawful machine gun with the trigger standing alone. What does this mean? This is who I have been contacted about in the past week or so. It is individuals who purchased directly from Rare Breed themselves, okay, directly from their website, and predominantly those who had the item shipped to them in a package that was labeled as Red Beard Treasures, okay? It appears that Rare Breed Triggers was shipping their items using a pseudonym of Red Beard Treasures. They claim to have done that to avoid package theft, and I have no reason to doubt that, because obviously if you are shipping things with a firearm manufacturer on the label, package thieves could quickly figure out what they might be getting their hands on. Now, of course, the ATF claims, no, they were doing this for far more nefarious reasons, but what do we expect the ATF to do? Now, if you have received one of those letters, or if you are thinking you may be receiving one of those letters, our advice has always been to get out in front of this right away. Contact local counsel. You can contact Washington Gun Law if you want, but this is not a sales pitch for that. There is many competent counsel right in your own backyard that can assist you with this issue as well. If you're having a hard time tracking who that person might be down in your state, feel free to contact Washington Gun Law. We can get the two of you connected. Do I believe you're in a ton of trouble? No, I don't necessarily believe you're in a ton of trouble, but you want to get out in front of this. And I'll circle back on why I don't believe you're in a lot of trouble. So that appears to be issue number one as it relates to these triggers. Now, the second issue is a lot of you are saying, well, hey, can they even enforce this? I mean, there's this injunction in place that the National Association for Gun Rights just won last week. That's not entirely true. First of all, has the National Association for Gun Rights absolutely been kicking some ass here? They most definitely have. I've had a chance to read their pleadings. They are doing really good work. The case we're talking about is National Association for Gun Rights v. Garland. It is a case that's filed in the United States District Court, Northern District of Texas in the Fort Worth Division. Last week, the trial court there issued a temporary restraining order, not an injunction, but a temporary restraining order. Let me explain to you the difference so you can understand this. We'll break it down in simple English. So this is how it works. When a party files a challenge to a law and asks for a temporary injunction, in some instances, it may be several weeks before you have a hearing on that temporary injunction. The problem is that between now and then, you continue to suffer irreparable harm. How can the court actually put a halt to the law immediately? Well, they do that with a temporary restraining order. So what the court issued here is a temporary restraining order that halts implementation of this rulemaking order until they have an opportunity to argue the merits of the full injunction, which is set for September 27th. However, and this is the big however, that temporary restraining order only applies to the individually named plaintiffs in that case. It does not apply to the class membership, that is everybody who is a member of NAGR. Now that could change. That could easily change. So that's food for thought for you. Now, I said that NAGR was absolutely knocking it out of the park, and I mean it here because sometimes the best lawyering that you could ever do was actually done by somebody else. And what NAGR, and they very wisely did this, is they said, hey, you know what? This issue has actually already been decided, and it has. Because let us remember that in the case of Cargill v. Garland, the Fifth Circuit has already ruled that the ATF's ban on bump stocks was without lawful authority. Why? Well, as we know, the federal definition of a machine gun requires that multiple rounds be expelled from the barrel for each single function of the trigger. However, when it comes to forced reset trigger, wide open trigger, and bump stock technology, the trigger is actually being used each and every time a round is expelled from the firearm, okay? It is not a single function of the trigger that expels multiple rounds. It is a single function of the trigger that expels each individual round. Now, there may be technology in place that allows the shooter to more quickly operate the trigger, and therefore we have a single function occurring more frequently, okay, and in quicker repetition. But the trigger has to function each and every time for a round to be expelled. And therefore, this does not, in a simple, plain English definition, it does not fall under the definition of machine gun by the United States government. Now, interestingly, in Washington State, we use a rate of fire, okay? And so had the United States government used a rate of fire to define what an automatic weapon is, then they might actually have some legs to stand on here, but that's not the case. And as the court put it in issuing the temporary restraining order, by comparison, the statutory definition does not define machine guns according to how quickly they fire. To qualify as a machine gun under the statute, a weapon must only be capable of firing automatically once the trigger itself performs a single function. And of course, the United States government to that is one where oftentimes when you get a government attorney kind of pinned in the corner, they come up with this argument, which is, don't believe me? Well, here's how the court addressed it. Defendants offer almost no rebuttal to the holding of Cargill controlling here. In fact, their response is relegated to a single footnote. This lone footnote contains the conclusory statement that plaintiffs have not carried their burden of demonstrating a substantial likelihood of success on the merits of their claim. Yeah, exactly. They did not demonstrate a likelihood of success despite the fact that there is a case directly on point advancing the very position that the plaintiffs were advancing here. The court even saw it that way when they ruled, because plaintiffs point to binding Fifth Circuit precedent that appears squarely dispositive of the issue in this case, the court finds that plaintiffs have carried their burden at this stage as to this factor and are entitled to a TRO. Okay, so the plaintiffs here got a temporary restraining order. It's in place until September 27th when they're going to actually have argument then on the full-blown injunction. Does that mean that all of us nationwide are enjoining this TRO? No, it does not. Does it mean that all of you who are members of NAGR at the current time are enjoining this TRO? No, you are not. The court issued a very limited temporary restraining order. The court ruled as follows. Thus, the court enjoins defendants from implementing or enforcing the ATF's expanded definition of machine gun that prescribes FRT possession against these individual plaintiffs. The implication of this TRO's narrow scope bear further explanation. This TRO protects only the individual plaintiffs from civil or criminal enforcement of the challenge rule during the life of the TRO. Other unnamed individual members of the institutional plaintiffs are not covered under this TRO. So right now, that temporary restraining order only applies to the individuals involved in that lawsuit. However, the court has extended the TRO beyond what is normally the time limit prescribed to go beyond September 27th, when we're going to have an argument between the parties as to whether or not an injunction should issue. And there is a likelihood that at that time, if the court issues a more permanent injunction, that the class of individuals to be enjoined could be much larger, including every member of the National Association for Gun Rights. Because let us not forget that the irreparable harm that the named plaintiffs are suffering is no different than the irreparable harm that you are suffering. So that is the two pieces of important information. We have a new set of letters going on. We have some successful lawsuit that is very promising, but doesn't provide you with the relief that you need yet. Now, I said also that I was going to circle back and talk to you about whether or not I believe you are in trouble. Do I believe that you're going to be indicted for a federal offense? Do I believe that ATF is going to show up with search warrants, kicking your door in and rummaging through your gun collection? Do I believe that you're facing a federal indictment? The bottom line is, no, I do not. Why do I say that? Well, because I've worked with hundreds of individuals in just about every single state, and not a single individual has been accused of a crime, charged with a crime, indicted, or even had any follow-up investigation once we resolve the FRT or WOT issue. Now, two of my clients were contacted by ATF later on to see if they would be willing to assist in the prosecution of some of the manufacturers. Neither of my clients had any interest in that, so we are done with them. I do not have a horror story yet about anybody communicating with ATF, me communicating on behalf of somebody with ATF that ultimately ended up being indicted for any type of criminal conspiracy. I will also tell you that with the absence of two prick ATF agents in Illinois, every other ATF agent that I've had the pleasure of dealing with has in fact actually been a pleasure, and we've been able to resolve these issues relatively quickly. Now, again, if you think you're going to be receiving a letter or you've received a letter, I do encourage you to contact counsel. That does not mean you need to contact Washington Gun Law. You may if you want, but there are many, many competent local attorneys that can assist you with this issue as well. That is the news as it exists today as it relates to forced reset triggers, wide open triggers, and everything that ATF is doing with Operation Reticent Recall. You may have more questions about this or anything else related to what's left of our Second Amendment rights. Now, you guys should know how to get a hold of Washington Gun Law by now, but if you don't, that's okay. That information is right down there in the description box as well. In the meantime, let's all remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.